In one of the most humiliating legal retreats in recent royal history, Prince Harry has officially backed down from his high-stakes libel battle against one of Britain's most powerful newspapers, and the fallout is absolutely explosive. The Duke of Sussex, who has spent years positioning himself as a crusader against what he calls the toxic British press, has just suffered a devastating blow that not only undermines his credibility but raises serious questions about his judgment, his legal strategy, and his increasingly complicated relationship with the country he once called home. This isn't just another royal headline, this is a seismic moment that reveals the widening chasm between Harry's public persona as a victim of media persecution and the harsh reality of legal accountability. What started as a bold challenge to press power has ended in an embarrassing surrender, documented in a stark 9-word legal statement that speaks volumes about the weakness of his case and the strength of the journalism he sought to silence. The implications ripple far beyond a single lawsuit, touching on press freedom, the limits of royal privilege, and the credibility of a man who has made fighting the media his defining mission. Prince Harry, the Duke of Sussex, fifth in line to the British throne, has become one of the most controversial figures in modern royal history. Born Henry Charles Albert David on September 15, 1984, to Prince Charles and Princess Diana, Harry grew up in the glare of international media attention that would eventually shape his entire adult life. The younger son of the heir to the throne, Harry experienced tragedy at a devastatingly young age when his mother, Princess Diana, died in a car crash in Paris in 1997 while being pursued by paparazzi. That traumatic event, which occurred when Harry was just 12 years old, would fundamentally alter his perception of the press and set the stage for decades of conflict between the prince and the media establishment. Throughout his youth and military service, Harry maintained a complicated relationship with tabloid culture, simultaneously benefiting from positive coverage of his charitable work and military deployment to Afghanistan while suffering embarrassing exposures of his private indiscretions, from his teenage experimentation with cannabis to the infamous Las Vegas photographs that showed him naked during a game of strip billiards. These incidents fueled a narrative of Harry as the royal wild child, the spare to the heir who could afford to be more reckless precisely because he would never wear the crown. Everything changed when Harry met Meghan Markle, an American actress of mixed race who starred in the legal drama Suits. Their relationship, which began in 2016 and led to marriage in 2018, became a lightning rod for media coverage that Harry and Meghan have consistently characterized as racist, intrusive, and fundamentally unfair. The couple's decision to step back from senior royal duties in 2020, in what the British tabloids dubbed Megxit, marked a dramatic escalation in their war with the press. Relocating to California, Harry and Meghan launched a series of public relations offensives against the British media, most notably through their explosive interview with Oprah Winfrey in March 2021, where they made serious allegations about racism within the royal family and the lack of support they received from the institution. Harry has since built much of his public identity around his status as a victim of press intrusion, authoring a memoir titled Spare that detailed his grievances and participating in the Netflix documentary series Harry and Meghan that further amplified his complaints about media treatment. Central to his mission has been a multi-front legal assault on various British newspapers, with lawsuits targeting alleged phone hacking, illegal information gathering, and defamation. The libel case against the Mail on Sunday represented one of the most significant battles in this campaign. The dispute centered on an article published by the newspaper regarding Harry's legal fight to maintain his police protection when visiting the United Kingdom. After stepping back from royal duties, Harry lost his automatic right to taxpayer-funded security, a decision he challenged through the courts. When that legal battle became public, the Mail on Sunday published coverage that Harry claimed was defamatory, alleging that the newspaper had falsely portrayed his actions and motivations in seeking to overturn the security decision. According to Harry's legal team, the article contained false and damaging claims that injured his reputation and suggested he had behaved improperly or dishonestly in his dealings with the Home Office regarding his security arrangements. The Duke filed his libel claim with great fanfare, positioning it as yet another example of his principled stand against a press he has repeatedly characterized as corrupt, dishonest, and willing to destroy lives for profit. His lawyers argued that the article went beyond fair comment on a matter of public interest and crossed the line into defamation by making specific factual allegations that were false and damaging. The Mail on Sunday, published by Associated Newspapers Limited, one of Britain's largest and most powerful media organizations, mounted a robust defense. The newspaper's legal team argued that their reporting was accurate, fair, and clearly in the public interest given Harry's status as a senior member of the royal family, albeit one who had stepped back from official duties, and the significant public interest in questions of security, public funding, and royal privilege. Associated Newspapers has been one of Harry's most consistent adversaries in the press wars, with their publications, including the Daily Mail and Mail on Sunday, frequently running critical coverage of the Sussexes. The company has deep pockets, extensive legal experience, and a philosophical commitment to defending press freedom against what they view as attempts by wealthy and powerful individuals to silence legitimate journalism. Their defense strategy in Harry's libel case involved not only disputing his interpretation of their article but also preparing to rely on statutory defenses available under English defamation law, including truth, honest opinion, and publication on a matter of public interest. English defamation law, while reformed in recent years to better protect press freedom, still places significant burdens on defendants compared to jurisdictions like the United States. However, the Defamation Act 2013 introduced important safeguards, requiring claimants to demonstrate that publication has caused or is likely to cause serious harm to their reputation, and providing defendants with robust defenses including truth, honest opinion, and a public interest defense that protects responsible journalism on matters of public interest. For a high-profile claimant like Prince Harry to succeed in a libel action, he would need to prove not only that the statements complained of were defamatory, meaning they lowered his reputation in the eyes of right-thinking members of society, but also that they caused or were likely to cause serious reputational harm. Given his already controversial public image and the constant media scrutiny he faces, establishing serious harm would present a significant evidential challenge. Moreover, if the newspaper could demonstrate that their reporting was substantially true or represented honest opinion on a matter of public interest, or that publication was in the public interest and they had acted responsibly in gathering and publishing the information, Harry's claim would fail regardless of whether the article was technically defamatory. The legal proceedings progressed through the initial stages with both sides filing extensive written submissions. Harry's legal team laid out their case in detailed statements of claim, identifying the specific words complained of, explaining their defamatory meaning, and asserting that the article had caused serious harm to the Duke's reputation. They argued that the newspaper had published false factual allegations rather than mere opinion, and that these allegations struck at the heart of Harry's honesty and integrity. The defense filed by Associated Newspapers challenged every aspect of Harry's claim, disputing that the words bore the defamatory meanings alleged, arguing that any defamatory meanings were substantially true or represented honest opinion, and asserting that publication was protected by the public interest defense. The newspaper's lawyers signaled their intention to fight the case vigorously, making clear that they would require Harry to undergo extensive disclosure of documents and give evidence under oath at trial, a prospect that would expose the Duke to searching cross-examination about his conduct, his communications, and his motivations. As the case moved toward trial, both sides would have been acutely aware of the risks and costs involved. English defamation litigation is notoriously expensive, with legal costs often running into millions of pounds even before a case reaches trial. The losing party typically faces an order to pay not only their own legal costs but also a substantial portion of the winner's costs, meaning that an unsuccessful claimant could face a seven-figure legal bill. For Harry, the financial risk was compounded by reputational risk, because a trial would involve intense scrutiny of his conduct, his veracity, and his motivations, all played out in public court proceedings that would be extensively reported by the very media organizations he was fighting. If the newspaper succeeded in proving that their reporting was true or that it represented legitimate public interest journalism, Harry would suffer not only a financial defeat but a devastating blow to his credibility and his broader campaign against the British press. The newspaper, for its part, faced the risk of a substantial damages award and the precedent-setting effect of a judgment that could embolden other public figures to sue over critical coverage. Behind the scenes, the realities of litigation were apparently becoming uncomfortable for Harry's legal team. The disclosure process in English civil litigation requires parties to search for and produce all documents relevant to the issues in dispute, a process that can be both burdensome and revealing. Harry would have been required to disclose communications with his advisors, his lawyers, and potentially with his wife and other associates regarding the matters covered in the article. Any inconsistencies between his public statements and his private communications could be exploited by the newspaper's lawyers to undermine his credibility. More fundamentally, as the legal analysis deepened and both sides prepared their evidence, Harry's advisors may have come to the sobering realization that his case was weaker than initially believed. Perhaps the words complained of could not sustain the serious defamatory meanings alleged, or perhaps the newspaper had stronger evidence of truth than anticipated, or perhaps the public interest defense was more robust than Harry's team had calculated. Whatever the specific factors, something clearly shifted in the evaluation of the case's prospects, leading to the dramatic decision to discontinue the claim. On a Friday, the formality of English civil procedure delivered the final word on Prince Harry's libel action through the filing of a notice of discontinuance, a standard legal document that allows a claimant to withdraw their claim before trial. The notice contained just 9 words that encapsulated the Duke's defeat, stating simply that the Duke of Sussex discontinues all of this claim. Those 9 words represent far more than a procedural step. They constitute an unambiguous admission that Harry was unwilling or unable to proceed with his case against the Mail on Sunday. In the unforgiving arena of libel litigation, discontinuance is universally understood as a defeat for the claimant, a recognition that continuing would be futile or too risky. While discontinuance does not involve a formal finding by the court that the claim was without merit, it is treated in practice as a vindication for the defendant, who successfully defended their journalism against a powerful critic who ultimately backed down. The immediate legal consequence of discontinuance is that Harry must pay the Mail on Sunday's legal costs, a financial penalty that could amount to hundreds of thousands of pounds or more depending on how far the litigation had progressed and how much the newspaper spent on its defense. Cost orders in discontinued cases typically require the claimant to pay the defendant's costs on the standard basis up to the date of discontinuance, meaning a substantial though not complete indemnity for the newspaper's legal expenditure. For a defendant like Associated Newspapers, with access to leading media law barristers and solicitors, those costs will have been considerable. Harry will also have incurred his own substantial legal costs in bringing the claim, none of which he can recover. The financial sting of discontinuance is therefore double, comprising both the sunk costs of his own legal team and the obligation to reimburse the defendant's costs. Beyond the immediate financial consequences, the discontinuance carries profound reputational implications for Prince Harry. His entire post-royal identity has been constructed around the narrative that he is a victim of an abusive, dishonest press that drove him and his wife out of the country and continues to persecute them through false and malicious coverage. He has repeatedly claimed the moral high ground, positioning his legal battles as a principled crusade for truth, accountability, and reform of a media establishment he describes as toxic and corrupt. The discontinuance of this libel claim fundamentally undermines that narrative because it suggests that when his allegations were tested through the rigorous process of litigation, when he faced the prospect of having to prove his claims under oath and subject himself to cross-examination, he chose to retreat rather than vindicate himself in court. The decision to discontinue sends a powerful message that whatever Harry believed about the unfairness of the Mail on Sunday's coverage, he was not confident enough in his legal position to put it to a judge. The timing of the discontinuance is also significant. Friday announcements in English legal practice are often used to bury bad news in the hope that the story will receive less media attention over the weekend news cycle. Whether Harry's legal team consciously chose Friday for this purpose is unknown, but the effect is to highlight the embarrassing nature of the retreat. Had Harry been confident in his case and committed to his crusade against the press, he would have relished the opportunity for a public trial where he could present evidence of the newspaper's wrongdoing and obtain vindication through a judicial ruling. Instead, he chose the quiet bureaucratic route of discontinuance, filing a procedural notice that avoids any public hearing or judicial comment on the merits of his claim. This stands in stark contrast to his public rhetoric about wanting transparency, accountability, and justice in dealing with the press. The discontinuance must be understood in the context of Harry's broader litigation strategy, which has involved suing multiple media organizations across several different legal actions. He has brought phone hacking claims against Mirror Group newspapers, alleging illegal voicemail interception, and in that case achieved a partial victory when the court found that some phone hacking had occurred, though the damages awarded were far less than claimed and many of his allegations were not proven. He has brought claims against Associated Newspapers over alleged illegal information gathering, which remain ongoing. He has sued the Home Office over the decision to downgrade his security, suffering defeat in the High Court but obtaining permission to appeal. This scattergun approach to litigation has been enormously expensive and time-consuming, consuming vast amounts of Harry's attention, energy, and resources over a period of years. The discontinuance of the libel claim raises serious questions about the sustainability and wisdom of this strategy. If Harry is going to discontinue cases when they become difficult or risky, what does that say about his commitment to the cause he claims to champion, and what does it say about the quality of the legal advice he is receiving? Critics of Harry's legal campaign have long argued that it is driven more by a desire for revenge against the press and a refusal to accept critical coverage than by any genuine principle or realistic prospect of success. They point out that Harry seeks the benefits of publicity when it suits him, cooperating with sympathetic journalists, giving high-profile interviews, and participating in documentaries that present his preferred narrative, while simultaneously demanding legal protection from any coverage he considers unfair or intrusive. This selective approach to media engagement, critics argue, reveals a fundamental inconsistency in Harry's position. He wants to be a public figure who shapes public discourse through his own media projects and public statements, but he also wants to be insulated from the scrutiny and criticism that inevitably accompany public life. The libel claim against the Mail on Sunday can be seen through this lens as an attempt to use legal intimidation to punish a newspaper for coverage Harry disliked, regardless of whether that coverage was actually unlawful. The discontinuance suggests that when the newspaper stood its ground and prepared to defend its journalism vigorously, Harry's case crumbled. Supporters of Harry, conversely, argue that the discontinuance does not necessarily indicate that his claim was without merit, but rather reflects the brutal realities of taking on powerful media corporations with vast resources and experienced legal teams. English defamation law, despite reforms, remains complex and expensive, and even claimants with strong cases can find themselves forced to abandon litigation due to the costs and risks involved. Harry's supporters point to the structural power imbalance between an individual, even a wealthy one, and a major publishing house like Associated Newspapers, which can afford to spend unlimited sums on legal fees and can absorb a defeat far more easily than an individual can. They argue that Harry's decision to discontinue may have been a pragmatic response to the recognition that the legal system is stacked in favor of media defendants, making it exceptionally difficult for public figures to obtain meaningful redress for even egregious invasions of privacy or defamatory coverage. From this perspective, the discontinuance is evidence of the need for further reform of media law and regulation, not evidence that Harry's complaints about press conduct are unfounded. Whatever one's perspective on the merits of Harry's position, the objective fact remains that he initiated a legal action claiming he had been defamed, and then withdrew that action before trial, exposing himself to a costs order in favor of the newspaper he had sued. In the cold calculus of litigation outcomes, this is a defeat. It is a defeat that the newspaper will inevitably publicize as vindication of their journalism and their right to report critically on public figures including members of the royal family. The statement from Associated Newspapers following the discontinuance was triumphant, emphasizing their commitment to defending press freedom and their satisfaction that the Duke had withdrawn his claim. Such statements are not mere spin, they reflect the genuine significance of repelling a legal challenge from such a high-profile claimant. Every time a media organization successfully defends a libel claim, it strengthens the precedent for press freedom and makes it slightly harder for the next wealthy claimant to silence critical coverage through litigation. The discontinuance also raises questions about Harry's legal advisors and the quality of the counsel he is receiving. Libel claims should not be brought lightly, especially by high-profile individuals who will face intense scrutiny if they lose. Responsible lawyers advise clients thoroughly on the strengths and weaknesses of potential claims, the likely defenses, the costs and risks, and the realistic prospects of success. If Harry's lawyers properly advised him on all these factors before he authorized them to issue the claim, then the discontinuance suggests that he chose to proceed despite being warned of the risks, and then lost his nerve when the reality of trial approached. If, conversely, his lawyers failed to provide proper advice and encouraged him to bring a claim that was always likely to fail, then he has been badly served by his legal team. Either way, the discontinuance reflects poorly on the decision-making process that led to the claim being brought in the first place. Litigation is not a game or a public relations exercise, it is a serious process with serious consequences, and bringing a claim that you later discontinue is a failure of judgment that carries reputational as well as financial costs. The personal cost to Harry extends beyond money and reputation to the emotional and psychological toll of prolonged litigation. Fighting multiple legal battles simultaneously is exhausting and stressful, requiring constant engagement with lawyers, review of documents, preparation of evidence, and the looming anxiety of potential trial testimony. Harry has spoken publicly about his mental health struggles, including anxiety and trauma related to his mother's death and his treatment by the press. One might question whether pursuing serial litigation against newspapers is conducive to healing and moving forward, or whether it keeps Harry trapped in a cycle of grievance and conflict that perpetuates rather than resolves his distress. The discontinuance of this claim offers an opportunity to step back and reassess whether the legal campaign is serving Harry's interests or merely deepening his sense of victimhood and alienation. The impact on Harry's relationship with the British public is also significant. Polls consistently show that Harry's popularity in the United Kingdom has declined sharply since his departure from royal duties and his subsequent public criticisms of his family and the country. Many Britons view his conduct as disloyal, self-indulgent, and hypocritical, particularly his complaints about media intrusion while simultaneously courting publicity through lucrative media deals. The discontinuance of the libel claim is likely to reinforce these negative perceptions, confirming the view that Harry is willing to make serious allegations but unwilling to back them up when challenged. Fair or not, public opinion is shaped by perceptions and narratives, and the narrative of Harry backing down from a fight he picked is not one that will enhance his standing with a skeptical British public. The implications for Harry's other ongoing legal cases are also important to consider. He still has active litigation against other newspaper groups, and he is appealing the decision on his security arrangements. The discontinuance of the libel claim may embolden his opponents in those other cases, signaling that Harry can be pressured into retreat if defendants stand firm and fight hard. It may also make judges less sympathetic to his claims, as a pattern of discontinued or unsuccessful litigation can create an impression that a claimant is abusing the legal process or bringing weak cases. While each case must be decided on its own merits, litigation history and credibility do matter, and the discontinuance is now part of Harry's litigation record. From a broader perspective, the discontinuance of Harry's libel claim is significant for what it says about the state of press freedom in the United Kingdom. Despite concerns about restrictive libel laws and the chilling effect of expensive litigation, British newspapers remain willing and able to defend robust journalism against legal challenges from powerful individuals. The Mail on Sunday's successful defense of this claim sends a clear message that newspapers will not be intimidated into silence by legal threats from celebrities, politicians, or even royals. This is important for democracy and public discourse, as press freedom depends on the ability of journalists to report critically on powerful individuals and institutions without fear of ruinous legal consequences. Had Harry's claim succeeded, it would have created a precedent that could have encouraged other public figures to sue over critical coverage, with a chilling effect on investigative journalism and public interest reporting. The discontinuance averts that danger and reinforces the principle that public figures must accept a higher level of scrutiny and criticism as a necessary cost of their public role. The case also highlights the role of strategic lawsuits against public participation, known as SLAPP suits, in contemporary legal and political culture. SLAPP suits are legal actions brought not primarily to vindicate legal rights but to intimidate critics, drain their resources, and silence opposition through the burden and cost of litigation. While Harry's libel claim may not technically fit the classic definition of a SLAPP suit, as he is not directly trying to silence political opposition or public participation, it shares some characteristics of strategic litigation designed to punish and deter critical coverage. The fact that he discontinued the claim rather than proceeding to trial supports the interpretation that the primary goal may have been to harass and intimidate the newspaper rather than to obtain a judicial vindication of his rights. If so, the failure of that strategy is a positive outcome for press freedom and the rule of law. Another dimension worth exploring is the impact on Meghan Markle, Harry's wife and partner in his media battles. Meghan herself has been involved in litigation against associated newspapers, bringing a successful privacy claim over the publication of a letter she wrote to her father. That case, which Meghan won on summary judgment without a trial, has been held up by the Sussexes as evidence that the press does act unlawfully and that legal action can be successful. However, Meghan's case involved a relatively straightforward issue of privacy law regarding the publication of private correspondence, quite different from the complex issues of truth, opinion, and public interest that arise in defamation cases. The discontinuance of Harry's libel claim creates an asymmetry in the couple's litigation record, with Meghan having achieved a victory while Harry suffers an embarrassing defeat. This may create tensions or at least awkwardness in their shared narrative of victimization by the media, as it becomes harder to maintain that narrative when one's own legal claims collapse under scrutiny. The role of Harry's American legal advisors also merits consideration. Since moving to California, Harry has surrounded himself with American lawyers and public relations advisors who may not fully appreciate the nuances of English media law and culture. American defamation law, governed by the First Amendment, provides much stronger protection for media defendants than English law, requiring public figure plaintiffs to prove actual malice, meaning knowledge of falsity or reckless disregard for the truth. American lawyers accustomed to that standard may have underestimated the challenges Harry would face even under the more claimant-friendly English system, particularly given the robust defenses available to media defendants and the high costs and risks of English litigation. There may have been a transatlantic disconnect between Harry's expectations, shaped by American advisors, and the reality of English libel litigation, leading to an ill-judged claim that had to be abandoned when reality intruded. The discontinuance also invites comparison with other high-profile libel cases involving public figures and newspapers. British legal history is replete with examples of celebrities and politicians who have sued newspapers for defamation, with mixed results. Some, like Elton John, Jeffrey Archer, and Jonathan Aitken, have achieved victories or settlements, though in cases like Archer and Aitken, subsequent revelations of perjury and dishonesty led to criminal convictions and the reversal of their libel victories. Others, like politician George Galloway and various celebrities, have won damages awards that vindicated their reputations and punished newspapers for false and damaging coverage. Conversely, many libel claims brought by public figures have failed spectacularly, with claimants suffering crushing defeats, massive costs orders, and permanent damage to their reputations. The graveyard of failed libel claims includes politicians, businesspeople, and celebrities who discovered too late that newspapers had solid evidence to back up their reporting or that the public interest in the story outweighed any reputational harm. Harry's discontinued claim now joins this latter category, a cautionary tale about the dangers of overconfidence in litigation and the resilience of press freedom. Looking forward, the question arises whether Harry will learn from this experience and modify his approach to dealing with media criticism. The rational response would be to accept that as a public figure, particularly one who has chosen to remain in the public eye through media projects and public statements, he must tolerate a significant degree of critical coverage. Not every unfavorable article is actionable, and not every actionable article is worth suing over. Strategic withdrawal from public life, or at least from unnecessary public controversy, combined with a more selective and thoughtful approach to legal action, would serve Harry's interests far better than the current scorched earth litigation strategy. However, Harry's behavior to date suggests an emotional and reactive approach to press criticism, driven by deep-seated anger and a sense of grievance that may not be amenable to rational recalibration. If he continues on his current path, more discontinued claims and failed lawsuits may be in his future. The impact on the royal family is another important consideration. Although Harry is no longer a working royal, he remains a member of the royal family and his actions reflect on the institution. The monarchy has traditionally maintained a dignified silence in response to press criticism, operating on the principle that responding to every critical article would be beneath royal dignity and would only fuel further coverage. Harry's departure from this approach, with his constant legal battles and public complaints, creates a contrast that makes the rest of the family's restraint look even more admirable by comparison. The discontinuance of his libel claim reinforces the wisdom of the traditional royal approach, suggesting that Harry's more combative strategy is counterproductive and damages his credibility. King Charles and Prince William must watch these developments with a mixture of sadness and frustration, as Harry's legal failures and public controversies continue to generate negative headlines about the family they are trying to lead and protect. The financial sustainability of Harry's litigation campaign is also questionable. While he and Meghan have lucrative deals with Netflix and other media companies, legal costs can quickly consume even substantial wealth. If Harry is paying his own lawyers and paying adverse costs orders from discontinued or lost cases, the financial drain could be considerable. There are reports that Harry has been required to provide security for the defendant's costs in some of his cases, meaning he has had to put up money in advance as a guarantee that he can pay if he loses. The accumulation of costs orders from multiple cases, combined with the ongoing fees for his legal representation, could amount to millions of pounds. At some point, even wealthy individuals must make hard choices about whether continued litigation is worth the financial cost, and Harry may be approaching that inflection point. The case also raises interesting questions about the future of defamation law in the digital age. While Harry's claim involved a traditional newspaper article, the same legal principles apply to online publication, and the explosion of digital media has multiplied the opportunities for defamatory content to be published and for individuals to claim reputational harm. The balance between protecting reputation and protecting freedom of expression is under constant pressure from technological change, social media, and evolving social norms about privacy and public discourse. Harry's generation has grown up in an era of unprecedented media scrutiny and online commentary, and his struggles with press coverage reflect broader tensions about how to navigate life in the public eye in the digital age. However, discontinuing a libel claim does nothing to advance the debate or develop the law. It simply represents a personal failure to vindicate one's grievances through the legal system. Another angle worth exploring is the psychological profile of someone who brings multiple legal claims against newspapers while simultaneously courting media attention through sympathetic outlets. This pattern suggests a complex relationship with publicity, where Harry desires control over his narrative and validation of his perspective, but reacts with hostility when media coverage challenges or contradicts that narrative. This is not unusual among public figures, many of whom exhibit similar contradictions, but Harry's case is particularly stark because of the intensity of his legal campaign and the explicit nature of his grievances. Understanding this psychology is important for understanding why he brought a claim that he later discontinued, as it suggests decision-making driven by emotion and a need to strike back at perceived enemies rather than by a cold assessment of legal merits. The role of public relations considerations in litigation decisions cannot be ignored. Every legal move Harry makes is analyzed by the media and commented on by royal watchers, commentators, and the general public. The decision to bring the libel claim would have been influenced not only by legal factors but by the desire to signal to the public and the press that Harry was willing to fight back against what he considered unfair coverage. Similarly, the decision to discontinue would have been influenced by the calculation of the reputational damage of proceeding to trial and potentially losing versus the reputational damage of backing down. In the event, Harry and his advisors apparently concluded that discontinuance was the least bad option, but the very fact that such calculations are necessary highlights the uncomfortable reality that Harry's legal campaign has always been as much about public relations as about law. The international dimension of this story is also significant. While the case was fought in English courts under English law, it has been followed by media and audiences worldwide, particularly in the United States where Harry and Meghan now live. American perceptions of Harry are generally more favorable than British perceptions, with many Americans viewing him as a victim of a cruel British press and an unsupportive royal family. However, even sympathetic American audiences may struggle to understand why Harry would bring a lawsuit and then drop it, as that pattern suggests weakness and indecision. The discontinuance may not damage Harry's reputation in America as much as it does in Britain, but it certainly does not help, and it complicates his ability to present himself as a winner in his battles with the press. One must also consider the impact on journalists and editors who cover the royal family. The discontinuance sends a clear signal that robust, critical journalism on royal matters will be defended by newspapers and will not be easily silenced by legal threats. This should embolden journalists to continue investigating and reporting on royal stories, knowing that their employers are willing to back them when challenged. At the same time, journalists must remain careful to ensure their reporting is accurate, fair, and defensible, as a successful libel claim against a major newspaper would have severe financial and reputational consequences. The balance between fearless journalism and responsible reporting is delicate, and cases like this help to define where that balance lies. The role of alternative dispute resolution in defamation cases is worth considering. English civil procedure encourages parties to attempt mediation or other forms of settlement before proceeding to trial, and many libel cases are resolved through negotiated settlements that avoid the costs and risks of trial. It is possible that settlement discussions took place in Harry's case, and that the discontinuance followed a breakdown of those discussions or a realization that no acceptable settlement was possible. However, discontinuance without settlement leaves Harry in the worst possible position, as he gains nothing but pays costs and suffers reputational damage. A negotiated settlement, even on unfavorable terms, would typically include some face-saving elements for the claimant, such as an agreed statement or clarification, and an agreement on costs that might soften the financial blow. The fact that Harry apparently discontinued without securing any such concessions suggests either that negotiations never got off the ground or that the newspaper saw no reason to offer any concessions to a claimant whose case was crumbling. The educational value of this case for other public figures considering libel litigation should not be underestimated. Harry's experience provides a cautionary example of the pitfalls of bringing a defamation claim without a strong case and a willingness to see it through to trial. Many celebrities and public figures are tempted to sue when they read coverage they consider unfair or damaging, but Harry's discontinued claim illustrates the dangers of acting on that impulse without proper legal analysis and realistic assessment of prospects. The lesson for other potential claimants is clear: do not sue unless you have a strong case, you have considered all the risks and costs, and you are prepared to follow through to trial if necessary. Anything less is a recipe for the kind of embarrassing defeat Harry has now suffered. The impact on legal precedent is minimal, as discontinuance does not result in a judicial decision that can be cited in future cases. However, the case will be noted in legal circles as an example of a high-profile claimant retreating from a libel claim against a major newspaper, and that fact will inform strategic calculations in future disputes. Lawyers advising media defendants will cite Harry's discontinuance as evidence that even wealthy and determined claimants can be forced to back down if defendants stand firm and fight hard. Lawyers advising potential claimants. Thanks for watching, and please don't forget to subscribe and hit the notifications bell for more upload.